I'm here to present AB 333, the Step Forward Act by Senator Kamlager, which seeks to bring due process to our gang enhancement statute. Our state's gang enhancements are wrought with prosecutorial overreach. If that overreach wasn't so widespread, we wouldn't be here today. And this bill would not have been included in the very first round of recommendations for reform by the California Committee on the Revision of the Penal Code. Let's start with some data. Gang enhancements are used disproportionately against people of color and have resulted in harmful systemic criminalization of individuals, families, cultures, and communities. 92% of people with gang enhancements in California are people of color. Notably, there is no empirical evidence that gang enhancements have been effective at reducing crime or protecting communities. But there is data that shows that longer sentences do not make us safer. Our gang enhancement statute has vague definitions, weak standards of proof, and are perhaps the most racially discriminatory part of our criminal justice system. AB 333 is merely a step in the right direction. We absolutely must go much further if we want to preserve any sense of justice in our criminal legal system. At its core, this bill is really about due process. It is time for us to stop relying on arcane and harmful tools like fear, bias, and stereotypes, and demand that prosecutors prove the charges that they levied against someone. AB 333 makes changes to the law that will reduce prosecutorial overreach by making the standards for applying a gang enhancement ever so slightly more rigorous. This bill does not make the application of gang enhancement impossible. I will restate that. This bill does not make the application of gang enhancement impossible. Rather, it requires that sufficient evidence be provided in order to prove that the underlying offense was actually committed on behalf of a gang. These sensible changes will ensure that gang enhancements are applied to only the most serious and violent offenses. Throughout the legislative process, the author has taken several amendments in the Assembly and the Senate, some taken directly from the opposition, and others that represent a middle ground to address some of the core concerns stated by the opposition. In the Senate, she has added back the predicate offense of burglary, qualified and limited the definition of, quote, benefit more than reputational by providing a list of examples of what a common benefit that is more than reputational may include. Amendments that were not accepted were those that were vague and raised valid concerns that would have watered the bill down to such an extent that it would no longer retain its original intent. Let me be clear. Once again, AB 333 does not end gang enhancements. It does not impact the length of gang enhancements, and it does not prevent street-level police investigations. It simply asks prosecutors to prove the gang charges brought against someone. In other words, it asks prosecutors to do their job. The same arguments used prior to prove a gang enhancement can still be used, so as long as they are germane to the charge. By addressing several damaging effects of, quote, gang evidence, end quote, at trial, and narrowing the applicability of such evidence, AB 333 takes an important step forward at undoing some of the harm caused by current gang enhancement statutes. I respectfully ask for your aye vote. Thank you.